The Court of Appeal sent it back to the court that had declined to hear it. The hearing was set for July 7, 2017. My lawyers filed a factum, and it put 3 questions to the court. The last one, were my rights under Sections 7, 9, and 10 of the Charter violated? 14 of its paragraphs were about the police, written in the third person, the way a factum is. That there were no legal grounds for the RNC to apprehend the applicant on April 7, 2015. That there had been no certificate of involuntary admission and no court order. That the apprehension was done without legal authority and consequently was an arbitrary apprehension and detention. Then the law it rested on. The Supreme Court of Canada, in Grant, a detention not authorized by law is arbitrary and violates Section 9. In the factum's conclusion, there was a breach of Section 9 of the Charter. The Act also sets out what an officer has to tell you when he apprehends you. 3 things. First, the reasons for his or her apprehension or detention. Second, that he or she is being taken to a facility for an involuntary psychiatric assessment. And third, that he or she has the right to retain and instruct counsel without delay. I was never given the reasons, only that a doctor wanted to see me, and on my own affidavit, filed with that factum, I was not told the third. 3 days before the hearing, a letter arrived from the counsel for the Chief of Police. It quoted the Court of Appeal back at my lawyer, that I had sought the vindication of having a Supreme Court judge affirm this, and then the Chief of Police was not named as a party to these proceedings. The next day, a second one. Unless you request that the court add the RNC as a party to this application, I must insist that you strike out paragraphs 15 to 28 of your factum. Both letters were copied to the court, 14 paragraphs, 2 days before the hearing. I had been forced to leave my family and move to Corner Brook for this. More delay is what they were offering. The judgment came 10 months later. I have restricted my consideration of this matter to a review of the actions of the 2 respondents, particularly the first respondent, and not members of the Royal Newfoundland Constabulary. Neither that organization nor individual members were named in the originating application. But the charter question was never only about the police. The judgment records, on its 3rd page, what I had filed in April 2015, that my detention was unlawful, and that my rights under Section 10 of the Canadian Charter of Rights and Freedoms were violated by the actions of the respondents. The second respondent was discontinued before the hearing. The hospital was not. That question is on page 3, and the judgment never comes back to it. What it did decide, decided on paper. By then, 2 doctors had sworn affidavits of their own. What they said, and what the judge did with them, is next. Every document in full, paradigmslip.ca/bad faith.